Hello students and welcome to the lecture. So students, as we know that we are covering the fundamental rights. Okay. And basically in the previous lecture, we had started our discussion over Article 22 and basically we had finished the Article 21A. Okay. And in the Article 22, basically we had discussed that there are two types of detention: the punitive detention okay, the punitive detention and the preventive detention. Okay, there are two types of detention basically we have here. Okay, so what do you mean by the punitive detention? Like when the crime has been committed, the authorities have arrested the accused. Thereafter, the process of collecting the evidences and all fulfilled, and then the person will be presented before the magistrate, and then it's depend upon the magistrate whether he is satisfied with the evidences and declared the person as an accused or not. Thereafter, preventive detention, if we talk about it, so we know that in the preventive detention, it is not necessary that the person has committed the crime. Okay, it is basically for the basis of precautionary or of preventive nature. Okay, that's the thing. So basically, we will start from where we had left in the previous lecture. I hope that you have revised the previous one in the well enough manner. Okay. So basically, we had discussed that the Article 22 has the two class. The first deals with the case of ordinary law. Okay. And here we are talking about the punitive, and the other one deals with the cases of preventive detention law. Here we are talking about the preventive detention. Okay. So basically, we know that the Article 22 confers the following rights on a person who is arrested or detained under an ordinary law. Like the first thing the authorities are required to do is to inform the person on which ground he or she has been arrested. Okay. Thereafter, second thing is that the person who has been got arrested by the authorities must be given the right to consult and the protection to be defined by the legal practitioner. Okay. Thereafter, we had discussed that there are right to produce before the magistrate within the 24 hours, including the journey time after being arrested. Like if someone was detained by the authorities, then he could not be detained for a long duration. He is required to be presented before the magistrate within the 24 hours. Okay. And then if the magistrate did not get satisfied that the person must be declared as an accused of that particular crime, then the person could be released within the 24 hours or after the 24 hours. Okay. But if the magistrate authorizes the further detention, then the person will be remain detained in the custody. Okay. For his judicial trials. All right. So these are the things. Thereafter, if we talk about this, so these safeguards are not available to an enemy alien or a person arrested or detained under the preventive detention law. What do you mean by the enemy alien? What is the meaning of this? So basically, if we talk about the rights and privileges or constitutional provisions. Okay. So if we talk about it, rights and privileges or the constitutional provisions, so we know that basically they are as per the for the citizens and for the aliens or foreigners. Okay, these are the ones. And we know that the foreigners are further divided into the two categories: friendly aliens and enemy aliens. So the friendly aliens are belong to those countries in which India is friends, or you can say they belong to those countries India friends with. And enemy aliens belong to those countries India having trouble with. Okay. So if someone belongs to the category of enemy alien, okay, then provisions of Article 22 does not apply on them directly. Okay. If someone belongs to the enemy alien category, but if someone belongs to the friendly aliens, then the provisions are available for them. So here we have seen two things, like these safeguards are not available for the enemy alien and for the person who get detained under the preventive detention law. Okay, it means that when the person gets arrested under the preventive detention law, there is no liability towards him by the authority, that the authorities are required to tell him on which ground he or she arrested. This, you can say, the person must be given a right to defend himself and all. Okay, and within present before the magistrate within 24 hours. So these safeguards are generally not applicable for them. Okay, thereafter you can say the Supreme Court also ruled that the arrest and detention in the first part of Article 22 do not cover arrest under the orders of the court, civil arrest, arrest on failure to pay the income taxes, deportation of an alien, all. Okay, like if some arrest has been made in the contempt of court. Okay, like you can say court has given you a summon, but you ignored it and you did not present before the court. Then what will happen? The court will declare it as a contempt of court and may issue arrest orders. Okay. So if any arrest has been made under the arrest orders which had been given by the court, then the person having no safeguards of Article 22. Thereafter, in the civil arrest cases, the Article 22 is not so applicable. And if we talk about the income tax cases, again, and if we talk about the deportation of an alien, okay, so on these grounds, the Article 22 is not applicable. Okay, they apply only to an act of criminal or quasi-criminal nature or some activity prejudicial to the public interest, like the terrorism and insurgents. Okay, so remember these things. Thereafter, if we talk about the B, the second part, which stands for the preventive detention. So the Article 22 grants protection to persons who are arrested or detained under the preventive detention law. Okay. Like the general safeguards which were available under the punitive detention, these safeguards are not applicable for them. But apart from those safeguards, there are other safeguards which are applicable for them. And thus, the protection is available to both the citizens as well as the aliens. And this includes the following. First, the detention of a person cannot exceed 3 months unless advisory board reports sufficient cause for extended detention. The board is to consist of judges of a high court. Okay, like if someone was detained on January, or you can say on 1st January, okay, then the person could not be detained for a time period longer than the 31st March. Okay, so the maximum time period for detention of any person under the preventive causes is only for the 3 months. Okay, if there is a necessity that the detention must be continued further, it means even after the 3 months, then basically the recommendations of the advisory board is required. Okay, and the advisory board is basically consists of the judges of a high court. All right, so the grounds of detention should be communicated to the detained person. However, the facts considered to be against the public interest needed not to be disclosed. Okay, like there is a general provision, not implicated one, but a general provision. If someone is getting detained under the preventive causes, then the person is, you can say, entitled to receive information or to get communicated, like on which ground the detention has been planned. But if the detention is against the public interest, okay, and you can say to safeguard the public interest, then there is no need to disclose the information. Okay, another thing we could see here is the detention person should be afforded an opportunity to make representation against the detention order. Okay, it means that if someone is getting detained under the preventive detention, then the person will get a chance to defend himself against the orders of preventive detention. Okay, so we can say Article 22 also authorizes the Parliament to prescribe certain things, like first, circumstances and the classes of cases in which a person can be detained for more than 3 months under the preventive detention law without obtaining the opinion of an advisory board. Okay, so we know that basically a person could be detained under the preventive detention for the maximum time period of 3 months. Then the person is required to be released. All right. So it is totally depend upon the Parliament. Like they could declare certain cases and certain circumstances in which they could detain a person for more than 3 months without taking the opinion of the advisory board. Okay. Thereafter, the maximum period for which a person can be detained in any classes of cases under a preventive detention law and procedure to be followed by an advisory board in an inquiry. Like if the Parliament wants, then they could even extend it or shorten the time period of detention. All right. And even they could, you can say, prescribe a procedure which is to be followed by the advisory board while launching an inquiry. And who is the member of advisory board? We had just seen the judges of high court. Okay. Thereafter, The 44th Amendment Act of 1978 has reduced the period of detention without obtaining the opinion of an advisory board from 3 to 2 months. Okay. However, this provision has not been brought into force, hence the original period of 3 months still continues. So we can say, like as I have told you, it's totally depend upon the parliament whether to extend or shorten the detention period. Okay. So in the 44th Amendment Act of 1978, basically they said that the period is now from 3 to 2 months only. Okay. But due to some reasons, you can say the provision is still not converting into the act. So that's why still, even after having the provision of 2 months, the 3 months is a prescribed tenure. Okay, that's the thing. Thereafter, if we talk about it, the constitution has divided the legislative powers with regard to the preventive detention between the parliament and the state legislatures. Okay, it means that the parliaments and the state legislatures having their different powers in order of the preventive detention. The parliament has exclusive authority to make a law of preventive detention for reasons connected with the defense, foreign relations, and the security of India. Okay. So if there is any circumstances and if there are any cases regarding these three fields, then basically parliament having the exclusive authority. The state legislatures could not make any law regarding on them in the matters of preventive detention. Thereafter, if we talk about it, another one. So both the parliament as well as the state legislatures can concurrently make a law of preventive detention for reasons which are connected with the security of a state, maintenance of the public order, maintenance of supplies, services essential to the community. So if there is any threat to these areas, and if there is any person who is possessing this threat, then this could be detained under the provisions of preventive detention. Okay. Thereafter, if we talk about the preventive detention laws, okay. So what are these laws? If we talk about it first, Preventive Detention Act 1950, which later expired in the 1969. Thereafter, Maintenance of the Internal Security Act, MISA, 1971, which later repealed in the 1978. Thereafter, Conservation of Foreign Exchange and the Prevention of Smuggling Activities Act, COFPOSA, 1974. Thereafter, National Security Act, NASA, 1980. Thereafter, Prevention of Black Marketing and Maintenance of Supplies of Essential Commodities Act, PBM SACA, 1980. Thereafter, Terrorist and Disruptive Activities Act, TADA, 1985, which got repealed in 1995. Okay, and this is basically, you can say, mainly designed for the Khalistani militants. Okay. Thereafter, Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substances Act, PIT NDPSA 1988. Thereafter, Prevention of Terrorism Act POTA 2002, which got repealed in 2004. Thereafter, Unlawful Activities and the Prevention Act UAPA 1967, as amended in the 2004, 2008, 2012 and 2019. Okay. Thereafter, it is unfortunate to know that no democratic country in the world has made preventive detention as an integral part of the country as has been done in India. It is unknown in the USA. Okay, like you can say that is the preventive detention as an integral part is the integral part of Indian Constitution and unique feature of it. Okay. Thereafter, it was restored to Britain only during the First and the Second World War. Okay. In India, preventive detention existed even during the British rule. Okay. Like we can say the idea of the preventive detention was basically developed by the Britishers, okay, during the First and the Second World War. All right. So now if we're talking about the First and the Second World War, so here is a question which I would like to ask you. Now you are required to tell me the timelines of First, Second World War. First World War, and the Second World War. For this, you have the 40 seconds, then I will give you the answer. And thus, your time starts now. 1, 2. Okay, First and Second World Wars, basically. So your time again starts now. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17th, 18th, 19th, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 33, 34, 35, 36, 37, 38, 39, 40. The time's up. So the First World War was basically happened during the 1914 to 1918. Okay. The Second World War was happened during the 1939 till 1944. Okay. So this is the timeline. Okay. So, for example, the Bengal State Prisoners Regulation Act of 1818 and the Defense of India Act of 1939 provided for the preventive detention. Okay, so we can say in India, if we talk about it, so during the British rule, or you can say during the time period of British India, still we have the preventive detention. Okay, and this is basically provided by various acts. If we take the example of it, so the Bengal State Prisoners Regulation Act of 1818 and the Defense of India Act of 1939, and the same year when the Second World War began. Okay, thereafter, after this, if we talk about the Article 23, prohibition of traffic in the human beings and the forced labor. This is the Article 23. Then basically this comes under the category of right against exploitation. And when we talk about the category of right against exploitation, so basically there are two rights, or you can say two articles, Article 23 and Article 24. All right, these two articles combined together forms the part of right against exploitation. Okay, so I don't think that we have a sufficient time so that we could discuss in detail. So just an overview that we have taken here. All right, so students, basically in this lecture we have finished it here. In the next lecture we will continue from here. Till then, just revise the facts and figures that all we have discussed in this lecture and be ready for the another lecture. With this note, let's end this lecture and thank you.